Hello, this is Dave. Today I thought I'd give a bit more clarity about templates and how to deal with responses. Now, this comes on the back of a friend of mine, Sarah. Now, Sarah was dealing with a bus lane violation, and she used the Lucy ULEZ template that you'll find in the files. This template asked for various bits of evidence, so I'll go through each item of evidence here. So item 1, please provide material evidence, not hearsay or opinion, which proves beyond a reasonable doubt that your notice was addressed to and intended for myself, the living woman, known as Sarah, and not the person named Mrs. Sarah Spencer. So that was to get around the assumption and presumption that that the living man or woman is the straw man that they are dealing with. Obviously, they can't charge a living man or woman. They have to engage with the legal fiction. So that really just challenges the presumption. Item 2. Please provide material evidence, not hearsay or opinion, which proves beyond a reasonable doubt that my private car was at location, at time, on this date. Item 3. If it can be proved that my private car was at this location at that time on that date, then please provide the name of the injured party and his or her sworn testimony detailing the nature of the tort. Item 4. Please provide a sworn testimony of 2 or more witnesses who have first-hand knowledge of the matter. Item 5. Please provide a copy of the lawful 2-party contract between myself and the council, bearing my wet ink signature, obligating performance, or material evidence, not hearsay or opinion, which proves beyond a reasonable doubt that your company has the power to force me into contracting with you. Item 6. Please provide the exact legislation which authorises you to impose a fine, charge or forfeiture before conviction. Item 7. Please provide material evidence, not hearsay or opinion, which proves beyond a reasonable doubt that the aforementioned legislation can impliedly repeal the Bill of Rights Act 1689, contrary to the ruling made in Thoburn v Sunderland City 2003. So those are the 7 items that were asked in the conditional acceptance, and again that's a Lucy ULEZ conditional acceptance template. You'll note that the last 2 questions are different from the standard speeding notice of conditional acceptance. That's because an NIP that you might get, a notice of intended prosecution, isn't actually imposing a fine as yet. It's just an offer of a prosecution. That's how they get around the Bill of Rights Act 1689, because they're not actually imposing the fine at that point. With a ULEZ, or in this case a bus lane violation, they're going straight to the fine. So those last 2 questions are there to rebut that, because they can't actually impose fines before conviction. So, looking at their response now. Dear Mrs. Spencer, thank you for the letter received on the 10th of January, addressed to Becky Shaw. I am tasked to respond to this and would be grateful if any future correspondence could be directed towards myself. Just take the heat off the CEO. Your letter raises a number of questions which I will respond to, but I think it may assist if I explain the process to you first. Well, we'll hold it right there. First of all, it mentions your letter. Well, you didn't write them a letter, you sent them a notice. A notice is very different from a letter. A notice notifies somebody of a process, a lawful process has started, and they need to be aware of it. Okay, so right there, they're trying to reframe your notice as a letter so it has no legal effect. it says, your letter raises a number of questions which I will respond to. Well, you didn't ask any questions. You asked them for material evidence of, that you were there. Okay, they weren't questions that they should respond to. Now, this is a trick, because if you don't rebut this, then what you did was ask questions, and any response to those questions is can be deemed as satisfying, each of your points. So now it goes on to explain their process. Under Traffic Management Act 2004, local authorities have a specific power. They've got power, given to them by Parliament, which allows them to impose penalty charges in respect of moving traffic violations. The details of those powers can be found in the Civil Enforcement of Road Traffic Contraventions 2022. On the 17th of October 2022, you were served a penalty charge notice because your car was seen driving in a lane reserved for buses. There is photographic and video evidence confirming that your car was seen there. As a result of the violation, you were fined £70. The £70 fee is laid down by Parliament, Schedule 3, Part 1 of the 2022 regulations as quoted above. The PCN made it clear that if you paid the fee within 21 days, that fee will be reduced to £35. That's the sweetener for the deal. Well, let's hold up for a second. Well, first it says you were served. Who's you? Yeah, so formally, the word you is a plural. So, you as in a group of people, So, who's you in this case? And it says your car was seen. Seen. Who saw it? Right? Now, again, this is a very tricky language, yeah? Because it says that somebody saw you driving, right? So it can't be the camera, because the camera didn't see you. Right, it recorded a photograph, but it certainly didn't see you. Right, and as it goes on, it says there is photographic and video evidence confirming that your car was seen there. So the photograph or video from the camera didn't see you. Literally, it confirmed that somebody else saw you. Who was that? Who were the witnesses? Right. So again, you have to really drill into the language here and look at what they're actually saying. Now, before we continue, notice that they didn't address point 1. So they didn't address the issue of who this was actually addressed to. So, that still comes under the heading of who is you. Okay, they didn't address that. So that's something else we're going to have to rebut. Okay, so they go straight to point 2. So point 2, again, it is not necessary to prove beyond a reasonable doubt that your private van, in inverted commas, was at Gildred Road, and hearsay and opinion are admissible. Wow, that's quite a statement. So hearsay and opinion evidence are admissible. In any event, camera evidence places your vehicle on the bus lane. So, going against what they said above, that the camera only is there to confirm, now they're saying that the camera evidence places you at the scene. So the big one there is that hearsay and opinion evidence are admissible. You might want to ask, where is hearsay and opinion admissible? Because they're not admissible in court. So what are they talking about? Moving on. Point 3. Being contravention of a moving traffic regulations is a breach of a statutory duty. Duty? We've got a statutory duty, do we? There is no injured party, nor is there a need to identify one. Well, that's good. They're telling us that it's not a crime. A crime requires an injured party. So if it's not a crime, it must be a civil violation which requires a contract. So moving on, point 4. It is not necessary to provide sworn evidence of 2 or more eyewitnesses to be liable to pay a PCN. That's right. It's absolutely correct. Eyewitnesses aren't necessary to be liable to pay a PCN. Eyewitnesses are necessary to establish that you were there. So again, it's word trickery, deliberate word trickery. Item 5. There is no contract between yourself and East Sussex County Council, nor does there need to be. As a vehicle user, you have an implied licence to drive on the road subject to road traffic law and regulations. Proceeding along a lane reserved for buses is not a right to which you're entitled. Well, actually, it is a right, because even the bus lane is part of the highway, the public highway. So them marking it off as somewhere you're not allowed to go is actually against our rights. But we can ignore that because they're going to ignore it. Point 6. I have quoted above the legislation that entitled the council to impose a fine on you. It is a civil offence, not a criminal one, so it can be imposed before conviction, in inverted commas. Right, again, more word trickery. I have quoted above the legislation that entitled the council to impose a fine on you, full stop. So that wasn't what you actually asked them for. You asked them for the legislation that entitled the council to impose a fine before conviction. So just there, that's again word trickery to make you believe that they're answering your question when they're answering a completely different one. The next part where it says it's a civil offence, not a criminal one, so it can be opposed. Now, I've come across this before. This was in my response to Canterbury that you'll find in the files as well. Now, the Canterbury actually went into a little more detail, and they said it was about a supposed ruling by somebody called Mr. Justice Collins, saying that the Bill of Rights 1689 does not apply because it's not a criminal fine, it's a civil one. But as I mentioned in that response, right, the Bill of Rights 1689 does not make a distinction between a civil fine and a criminal one. Right? It's there to stop an innocent person being punished before conviction. That's the intent of that Bill of Rights Act 1689. So again, they're trying to test you to see if you know your stuff. Number 7, the case of Thoburn versus Sunderland City Council 2022, which you quote, is the so-called Metric Martyrs case. It deals with the interaction between Weights and Measures Act and the European Communities Act 1972. It has no relevance to your situation, and I will not address it further. Well, again, yes, the correctly quoted what the Thoburn versus Sunderland City Council case was about, but they're not referred to the ruling that was made in that case, which upheld the Bill of Rights Act 1689. So yes, obviously they don't want to address it further because it supports the point above. So it is a matter for you whether you commence legal proceedings against the council, but such proceedings will be strongly resisted and costs sought against you in full on an indemnity basis if you proceed down this route. You may wish to seek legal advice. Yours sincerely, Mrs. Turnbull. You can't see the bottom there, but it's Mrs. Turnbull. Right, so that was their response. Now, can you see that all they have here is word trickery? And this is where our approach is very powerful, because what you have on your side is the truth, right? They have no evidence against you. There was no actual violation of anything. You don't have a contract with anybody, so no charges can be imposed. It's all about word trickery, and they're trying to get around your request for information, your request for evidence, by word magic, word trickery. And to the untrained eye, to anybody, any of the muggles out there who, just try to use a template. So if they just literally took the template, the ULEZ template, and pasted in their names, sent it off, and got this response, this would terrify them. This is what would get the muggle, coming back at you saying, "What do I do now? What do I do now?" Because as far as they're concerned, they'll see this and think, well, they've answered all the questions. What have I got? What can I do next? Right? But as you can see, every one of their attempts at addressing the request for evidence was not done so in substance. There was no response with substance. So there was no evidence, no proof provided. So this is a response I drafted up. Now I suggested to Sarah to wait till the notice of conditional acceptance expired and respond in her notice of default and opportunity to cure. So this is that document. Dear Becky Shaw. So right there, I'm getting to write directly back to the CEO, not right back to Mrs. Turnbull, and you'll see why in the further on in the letter. Dear Becky Shaw, on date, you were served a notice of conditional acceptance, accepting your PCN number, on condition that you provided the following material evidence within 7 days. And then you can put the list of evidence required. On date, a letter was received from a Mrs. Turnbull, and although Mrs. Turnbull asked that I direct all subsequent correspondence to her, judging by the calibre of her response and apparent lack of legal awareness, I thought that you might want to handle this yourself, or at least assign someone who knows what they're talking about. In the aforementioned letter, Mrs. Turnbull referred to my notice of conditional acceptance as a letter, despite the title being written in bold letters beginning with the word notice. It was a notice. It informed you of the beginning of a lawful process as a diligent attempt to arrive at a binding agreement between parties, according to King James 1611 Bible. Matthew 5:25. Agree with thine adversary quickly while thou art in the way with him, lest at any time the adversary deliver thee to the judge, and the judge deliver thee to the officer, and thou be cast into prison. Mrs. Turnbull states, you were served with a penalty charge notice. Who exactly is you? In such a formal setting, you is a plural. And I remind you that the requested item number 1 is required to be established by you to determine exactly who you is referring to. Mrs. Turnbull goes on to say that a car bearing the number plate number, we have yet to establish that this car and my private van are one and the same, was seen driving in a lane reserved for buses. Ignoring for the moment that cars do not drive, driving is a commercial activity where a driver is employed to transport goods and passengers from place to place, using a car, bus, coach, team of horses, etc. Thus, the car does not drive, the car is driven. Who are the witnesses to this offence? As Mrs. Turnbull correctly states, the camera can only confirm witness statements. And item 4 of the requested evidences formally requires you to provide the sworn witness statements of 2 or more witnesses with first-hand knowledge of the matter at hand. Mrs. Turnbull also stated that she was responding to questions. However, I did not ask you, her, or anyone else to respond to questions, nor am I interested in an explanation of your process. You are required to provide material evidence of your claims, which it was noted that Mrs. Turnbull failed to do so on your behalf. Legal maxim. Semper necessitas probandi incumbent qui agit. The claimant is always bound to prove. The burden of proof lies on him. For future reference, because we say so, cannot be considered as material evidence. I note that Mrs. Turnbull completely ignored the first and most important of the requested items of evidence. Number 1. Please provide material evidence, not hearsay or opinion, which proves beyond a reasonable doubt that your notice was addressed to and intended for myself, the living woman known as Sarah, and not the person named Mrs. Sarah. There is a doubt whether your correspondence is in fact addressed to and intended for the living woman known as Sarah. This must be resolved in writing with material evidence, as it may be the case that I am opening Mrs. Nep's mail in error. Point 2. What an interesting claim that proof of claim is not necessary and that hearsay and opinion are admissible. Where exactly is hearsay and opinion admissible? Would that be at Mrs. Turnbull's house? Does that mean I can claim that Mrs. Turnbull's house now belongs to me, because that's what I believe, and my friend Billy the Fish says so too? Will Mrs. Turnbull hand her keys over to me? No. Hearsay and opinion are not admissible anywhere, and they are certainly not admissible in court. It is indeed lucky for Mrs. Turnbull that she also failed to provide the requested evidence in the correct format, namely in affidavit format sworn under oath or attestation, under penalty of perjury, and upon her full commercial liability that the facts contained therein are true, correct, complete, and not misleading. Because her claim would be considered perjury, and I would hold you both liable for that. It is also interesting that she believes that the camera provided some sort of evidence. Should this matter proceed to court, please ensure that the camera is in court and available for cross-examination. As stated in my notice, I have no record of either myself or my private van being at location, on, date, at time. So I will require the material evidence that myself and or my private van were involved in the alleged offence. Item 3. I thank Mrs. Turnbull for confirming that no crime took place. Therefore, your claim must hinge on some sort of contractual breach, and thus requires a contract. Item 4. Mrs. Turnbull is correct. Witnesses are not necessary to establish liability to a PCN. However, in the absence of evidence, at least 2 witnesses are required to establish that myself or my private van were involved in the alleged offence. Deuteronomy 19:15. At the mouth of 2 witnesses or at the mouth of 3 witnesses shall a matter be established. Item 5. Mrs. Turnbull's claim that there does not need to be a contract between myself, the living woman known as Sarah, and East Sussex County Council is baffling, because in Parking Eye Limited versus Beavis 2015, the case centred on the law relating to penalty clauses in contracts, in particular contracts formed by the placement of notices. I also looked up civil penalties and found the following definition. Penalties in English law are contractual terms, which are not enforceable in the courts because of their penal character. Chitty on Contracts, Volume 1, 31st edition. So a penalty charge arises from a contract, and I also note that they are not enforceable in the courts. Item 6. It appears that Mrs. Turnbull misunderstood what was being asked of you. I required her to provide the exact legislation which authorises you to impose a fine before conviction. Having read through the Traffic Management Act 2004 and Civil Enforcement of Road Traffic Contraventions 2022, I am unable to find a section which repeals or impliedly repeals the Bill of Rights Act 1689. please direct me to the relevant section. In stating that a civil offence may impose a fine before conviction, Mrs. Turnbull was no doubt referring to the supposed ruling by Mr. Justice Collins, which cannot be considered case law because case law are made by the decisions of juries. Judges merely comment upon the ruling arrived at by the jury. So while Mr. Justice Collins' opinion in this matter might be interesting, it is equally irrelevant. Mr. Justice Collins stated, This is not a fine or forfeiture within the meaning of the Bill of Rights. The suggestion that the bill applies is a nonsense. It does not. Parking charges were not fines for criminal offences. It was implicit in the 1991 Road Traffic Act that they were civil penalties. The Bill of Rights Act 1689 makes no distinction between fines for criminal offences and fines for civil violations. It relates to any fine or forfeiture before conviction. In this country, one is presumed innocent until proven guilty. The punishment of the innocent before conviction is precisely what the Bill of Rights Act 1689 was instituted to prevent. And the general ignorance of this statute invites unscrupulous agencies such as East Sussex County Council to circumvent the people's right to due process of law. Item 7. Mrs. Turnbull is to be commended on her Google skills. The case of Thurburn v Sunderland City did indeed revolve around the Weights and Measures Act. However, the ruling in that case upheld the Bill of Rights Act 1689 as a constitutional statute, which may not even be impliedly repealed. In the case of Thurburn v Sunderland City 2003, it was ruled we should recognise a hierarchy of Acts of Parliament, as it were, ordinary statutes and constitutional statutes. The special status of constitutional statutes follows the special status of constitutional rights. Examples are the Bill of Rights Act 1689. Ordinary statutes may be impliedly repealed. Constitutional statutes may not. Thus, there can be no statute that can impose a fine, civil or criminal, before conviction. And this includes, but is not limited to, the Traffic Management Act 2004 and the Civil Enforcement of Road Traffic Contraventions 2022. Your response does not represent a diligent attempt to provide the requested evidence and proofs of claim with substance. And should this proceed to court, I will be seeking costs against you because I am making a diligent attempt to resolve this matter, whereas thus far you seem to be making a confession and avoidance plea. However, I understand that Mrs. Turnbull may not have understood what is required of you. I offer you an additional 7 days to cure this default by providing material evidence with substance and documentary proofs of claim in affidavit format sworn under oath or attestation under penalty of perjury and upon your full commercial liability that the facts contained therein are true, correct, complete and not misleading. If you fail to respond in good faith and according to the above criterion, it will be deemed a tacit agreement by your acquiescence that there is no evidence that myself and or my private van were involved in the alleged offence, and that all parties, to mean you and your principal and other parties, abandon all demands upon me. Sincerely, without malice, ill will, vexation or frivolity. And just for a laugh, I put a PS. PS. Please provide Mrs. Turnbull's full name and address, as myself and Billy the Fish are curious to
Sorry. Sorry. Oh God.
Okay.
Okay. I'm shutting up now.
Okay. So I added a PS. PS. Please provide Mrs. Turnbull's full name and address, as myself and Billy the Fish are curious to see my new house. So that's basically it. It should be obvious that again, we have right on our side. We have truth and honesty on our side. All they have is word magic. Yeah, they are constrained by a need to look like they're being honest, just, and truthful, because if the muggles at large figured out that it's all a sham, heads would literally start rolling. So they've got to look like they're doing the right thing, right? That's their constraint. Now, you can see by their words of art, their word magic, yeah, they're kind of skirting the truth. Yeah, so they're telling the truth, but they are actually lying to you, and they're trying to trick you into going along with their process. So I hope this has been useful. So when you start getting responses from your templates, you want to read first of all, read what you've sent them, read what you've asked them to provide. Right? Your first question when you're looking at their responses is have they provided what you've asked for? The obvious answer is no, they haven't provided you that what you've asked for. So the next thing is to look at their response and pick out all of the intentional mistakes, misunderstandings, assumptions and presumptions. Because if you fail to rebut them, then they become the truth, and they have remedies for the things that now they presumed that you've done. So just look at everything that they've written and rebut it. Okay. Hopefully, now once you've got to the stage yourself, you'll be able to see through their word magic. Thanks for listening.